Hello, everybody. Welcome to the April edition of the Third Fridays podcast. And I think we have a little treat for everyone today, or really the treat may be for my guest.
Oh, it's definitely for me. I've never been so excited to be asked to speak anywhere. I've addressed conferences, clients, our office, and I've never been so honored. I can't believe this podcast has gone on for years now.
More than 2 years. More than 2 years.
And you've never invited me on today.
Yeah, so either this is going to go very well, or this might blow up in smoke. We'll see what happens, though. Everybody, if you can't recognize my guest voice, is the esteemed named partner of this great firm, Gregory Lois.
I'm so happy to be here.
Welcome to the show.
And all I had to do was arrange other people's schedules because I was not your first choice today to be your guest. You had someone else, and I arranged to get him out of the state.
You actually haven't been my first choice for 2 years, and you've managed to wrangle yourself into this little shindig by, you're right, you switched around some scheduling. Maybe there was a quote-unquote technology snafu, which I don't believe for a fact had ever actually occurred. But here we are. Technology's working. So
thanks for having me. Thanks. I mean, no, I'm not your first choice, but I am excited to be here. Right. So what's the topic? I have no idea.
Backups have fun, too. So the topic is, and you're going to make me play this game where I announce it to you, is general special employment. Now, we know that earlier this week, you yourself performed a very riveting webinar on employer-employee relationship. We have a lot of experience defending those claims. Sometimes that issue is very black and white, right? Like, this guy is not on my payroll on the date that he supposedly got hurt, right? And then it becomes a situation where we just produce the records and get out, right?
Right. Easy.
How often would you say that type of employer-employee relationship defense occurs, the easy one, as opposed to the harder ones?
Not that often, to be frank with you. I mean, generally speaking, people know who their employer is, right? They have a payroll, they have a uniform, they have a pay stub, they have tax records. I mean,
we actually probably don't see a lot of those files because it's so easy,
right?
They just, pick someone who can just show up to a hearing and present a piece of paper and doesn't really require the nuanced legal arguments that a firm reputable as ourselves would make, right?
Sure. Yeah, no, I mean, those are the simple ones. The ones that we see more typically are ones sometimes where the employer got dragged in by the employee who has no idea who they worked for. Maybe they were a day laborer and they're on a construction site.
Right.
And they got injured in some way and then really don't even know who hired them. They just know the name of one or two people maybe on the site. And they'll just walk around the site and just sort of point their cell phone at every single construction vehicle on the site and get all the names, and then they'll just bring a claim against everybody and say, the workers' compensation courts will figure this out, who my right employer was. So they start up all different ways.
Right, and I think the road that this leads to is sometimes we get so entrenched in that specific defense that all the litigation leads up to a certain actual point for the judge or the board to make, and all the while you've lost your defenses because you've been so hamstrung on this fact that this guy is not my employee, right? So that's the first thing I wanted to go over is essentially that when you're raising these defenses, right, you also want to make sure that there somewhere down the line you might be held to be the proper employer, even though you really believe you're not. And it's important to make sure that we're pursuing all other avenues. I think we have a great model here where we make our clients aware of the fact that, hey, let's pursue these other ones too as protective measures, right?
Yeah, I mean, the entertaining moment is if you only plead as a defense employee-employer relationship, well, you're waiving all those other defenses, like notice, right? The person's not my employee. How could he possibly give me notice? I mean, what you might think is just normal human beings that's logical. So why would I have to affirmatively plead notice as a defense where I'm claiming this guy is not my employee and never would report an injury to me anyway? Well, the board's going to preclude that defense if you don't affirmatively raise it, even as nonsensical as that could be or as common sense as that could be.
Yeah, and the case is just going to go on by, and then all of a sudden he's building up this exposure which you haven't defended because you're going on a real factual argument, and then the legal hits you at the end, and then you can't really defend the amount of blood that comes out of that stone.
Sure.
Right.
Right.
So Let's talk about that harder employment case that you had just brought up, where someone who doesn't know who their employers, or maybe they maybe actually know that they are employed or at least been given direction by multiple companies, right? Mm-hmm. And I feel like that's where general special comes in, and it's a term in our industry where, for instance, we have clients that contract with other entities to share operations, share locations, and employees, right? So there is an actual question of fact that the board has to go through to determine, is there only one employer, or is the person a special employee of another entity that may not have been involved in certain facts of his employment, but will be liable, right?
Sure.
So we have a case that came down in the appellate division this past October. It didn't really bring anything new to the game here, but it really affirms some of our policies and procedures, and also sheds light on how the board can really react to certain cases like this, right? So we have a trucking company. Its name is Eaton, right? And they lease a lot of their vehicles and employees and locations to another company called Quality Carriers, right? And so Quality takes Eaton's employees and they use them as they see fit to haul goods across the country. Eaton owns the vehicles, right? Eaton hired this particular claimant. They trained him. Quality Carriers retain the right to discipline them. They gave him the schedules, right? They provided insurance for Eaton's trucks. And now you have this case where both hands are kind of in the pot, mm-hmm. right? And the Quality Carriers appeals a finding of special employment. The judge essentially decided it's 50-50. So whatever carrier was indexed, we'll pay the whole of it, and then we'll get reimbursed 50% from the other special employer's carrier. Mm-hmm. How would you go about defending this matter for either one of those trucking companies when it seems like it's very hard to get out of, it's very hard to achieve a full dismissal when your hands are a little bit in the pot?
Right. Well, when one employer has the right to control, direct, or discharge another alleged employer's employees, you're going to lose that almost 100% of the time. I mean, that's really the test. Who has the right to direct and control? And certainly the ability to discharge would impute the ability to control. And I also think that I understand the positions of the employers, right? So I'm taking in all these leased employees or these Lent employees or however you want to call it, these dual employees, and I have them on my premises. Well, I don't want these mavericks doing crazy things. So I might say, hey, I'm going to take your employees because, just from a benefits and payroll perspective, this is a good deal for me. But I don't want a crazy lunatic working for me and, who could tarnish my brand image.
Right.
So I want the right to separate this person.
Sure.
And, okay, guess what? Now you've just become their employer. Regardless of the sort of legal arrangements that you've created with this lending employer, by doing that, you've now taken them on.
Yeah. And what kind of is funny to me is that, both employers in this, and we've seen this many times, where both employers believe it's the other person mm-hmm. that's the employer, right? Mm-hmm. Would you ever consider, as an employer, or maybe as an attorney for an employer like we are, to ever suggest to your client, hey, let's agree with the other employer that we both share responsibility, so that we can work together and then mitigate damage from the start of the claim, as opposed to fighting it out, whether it's me or you, mm-hmm. on day 365, and then get hit with all the exposure from day one.
Well, that's what's a little bit surprising about that decision in particular. Most of the time, most of the relationships that we see with a lending employer, and then the other employer who's maybe taking that employee on, and that employee is doing, by the way, the direct work of the borrowing employer. I mean, there's no doubt that this is someone who's doing something integral to their business. Most of the time, they have an agreement between them,
yes,
right? So the lending employer will say something like, okay, we know that we can go to workers' comp court, and workers' comp can look at this arrangement and say, hey, you're both the employers, you're both on the hook. Therefore, I will indemnify you. I will hold you harmless. Should you be found to be an employer and be found to be on the hook for workers' comp benefits, I'll indemnify you. And that's typically how they sort of resolve that.
Right, like staffing companies, right? Yeah. Like, we have a lot of those where they know that they're going to be providing coverage to mm-hmm. Their employees. It's truly their employee that they're, giving them temporary status as far as, working for another employer, right? It's true. There's an agreement in place. These cases, you're right, only come about when there is no agreement, right?
Right. I mean, that's the odd man out. The other situation is, or something to be thoughtful about as the lending employer, the employer giving people to somebody else. Hey, by the way, you're going to now be indemnifying maybe. We're on the hook for a lot of risk that you don't even know what it is. And that's something, like these two parties are going to enter into this sort of arrangement. And one party ends up sort of insuring or carrying the risk for the other party. And that's something to be mindful about. We also see circumstances, or particularly in the circumstance you mentioned, where you're giving the lending or the borrowing employer, the right to discharge your employees.
Right.
I mean, that's pretty extreme. There's also case law where things like when the borrowing employer gives them a uniform, right, with the borrowing employer's name on it
and a logo,
a logo. That's enough. Now that they're carrying on as if they're in your business. So you don't even have to go to the extreme of I can separate your own. I can terminate your employees because they might harm my brand image.
Right.
There's a
You're
much
already
lower threshold.
giving him the brand image, actually.
Yeah, actually, yeah. So there's a much lower threshold, and that's why those situations are more complicated. Yeah.
Right. And I think too, it's almost like that old law school theory where it's like you're holding that person out so that a reasonable person would look at that guy with the T-shirt on and say, you know what, that you're an employee of that person. Like how is anybody else supposed to know? So why should the courts treat you any differently? I think what's interesting.
Law school misses the whole thing too, which is
law school miss something.
They miss a lot. Okay, but here's the other thought. You're the defense attorney. You're defending one of those two employers, either the borrowing or the lending employer. Okay, well, their interests are not aligned with either the borrowing or the lending employer. But guess what? Those two people, your client and the other person, whether it's the borrower or the lender, they have an ongoing business relationship, which might be millions and millions and millions of dollars in payroll and hundreds of employees between the two of them. And so now you're trying to defend a case in which I'm going to try to push the risk. Let's say I'm defending the lender.
Right.
I'm going to try to push the risk to the borrower, who's your huge client.
Right.
No, that's a problem, right? And that's something that you'll never get to in law school. The idea, because everything's so sterile and it's in this academic environment. But the practical aspect is, a lot of the times where we have a borrowing and a lent employee, there's the borrower saying, I will take the exposure because I don't want to screw up. Or the lender will say, I'll take the exposure because I don't want to screw up my relationship with this borrower who, by the way, Greg, sends me $500,000 a month in business. That's right. That's why these arrangements are created.
Right. I think you're more sophisticated employers, right? Like, bring back to what you said about day laborers, right? It's like the sophisticated employers are either going to have contracts written up to make sure that everybody knows who would be liable, or they have the relationships with the lent employer or the lending employer or the borrowing employer, that they would come to the realization and say, is this worth it to me ruining this relationship by saying 100% of the risk, you take it, it's not me, I only did A, B, and C while you did the rest of the alphabet, right? So you're really only talking about these special cases where it's the employers may not have a sophisticated or long-term relationship, and or they don't have the contractual agreement that would push liability and make it crystal clear, right?
Sure.
So, this general special, these two trucking companies that may not have this type of situation in place, you're going to be kind of litigating that and really severing the relationship.
Yeah, it's going to get ugly.
What happens.
It's going to get ugly,
right?
And we have to be sort of prepared for that.
So let's put us in that situation then, right? Where we've made the determination that there is going to be no relationship with the other employer at the end. Would you then still consider either stipulating to some percentage of liability, or would it make sense to then go full force and go, he's 100% your guy?
You try. You make the pitch. At the end of the day, I can't, the judge is going to say, well, you did this, you did that. And, the other thought that we would have to explain to the clients is, look, you guys created this relationship between the two companies or the two entities. And there was a point of it. There was either a tax savings or a benefit savings, or there is some business position behind that decision. And, when we're counseling that client or either of those clients, they'll often say things like, Greg, how could this guy ever be found to be my employee? Because I have we pay the taxes on a 1099, or they'll look to sort of the IRS status of the person or the other entity, and they'll go, look, I mean, we've created these, and sometimes we have to counsel them that, well, the workers' comp judge doesn't care whose name's on the pay stub or what he says
as long as there's someone.
Right, as long as there's someone, and they're going to look at who directs and controls regardless of who writes the check. And so that's a very different standard or a different thought for them to sort of absorb or, realize that we're really going to look at who was controlling that person, not who paid them, or the independent business relationships the two entities had together, or, whatever legal artifice that we've created to sort of explain this away or to avoid taxes or whatever the point of this relationship is, because there is a point to it. But that's not going to carry the day. And more than that, we're going to be almost hamstrung. I don't even want to bring that into court. I don't want your contracts. You don't want your contracts to be revealed in workers' comp court. I mean, they might contain proprietary business information or business secrets or rates or other stuff that you don't
become
want
discoverable.
Right. You don't want it out there. Yeah.
It's a good point. I think that it actually brings this niche industry that we're so much a part of and elevates it to higher level discussions of how it affects a business, because that's what we do here, right? Like, the defense of your business is our business, right? So using that to implement and give real world advice as it relates to just an underlying workers' compensation claim, but really showcases how big this kind of one-off
the issues are
claim
huge. And think about too
on.
the large scale staffing company or PEO.
Sure.
Right. I mean, their number one business expense on their profit and loss statement is salary.
Right.
And probably number two is workers' comp.
Right.
This is a huge proportion of their business that's getting affected by this. And, generally those...
You could even make the argument that workers' comp, even being second, is more of a risk because the exposures are variable. The salary is more or less fixed, right? You can project salary for a certain amount of years, but workers' compensation exposure just jumps through the roof.
It could be all over the place, particularly if they're self-insured, too.
Right.
I mean, in which case the reserves are actually hitting the bottom line in those circumstances. So, yeah, certainly. The big staffing companies, the big PEOs, like, they're going to be pretty sophisticated, but it's where you get the relationships like the ones you're talking about between a trucking company and a staff leasing company that maybe only has one client, right? Because I don't know too much about the background facts of that case. That's not our case, that Quality Carriers case. But who knows how entwined those two businesses really are? I mean, did you get to a situation as this over-the-road trucking company, let's say, where workers' comp is a huge proportion of their overall costs, and they say, okay, here's what we're going to do. We're going to spin out all of our employees into this staffing company, which is going to be basically captive to us. It'll just supply people to us, and we'll keep the right to fire people, et cetera. So there's going to have this quasi sort of mixed relationship. And maybe they did that because they couldn't get workers' comp coverage in the general market anymore, or because they had, who knows what was the reasoning sort of behind that. I don't know. But those are definitely the sorts of things we need to be sensitive to.
Yeah, I think we can certainly see if one of the employers is willing to bring it all the way up to the appellate division, it's probably not a relationship that's
getting salvaged.
It's not savable. But it's a good reminder of how a case can really just balloon to something crazy if we're not careful in the beginning. And some of it is also doing this kind of damage control that we're talking about. It's like, can we sever this relationship and really move on with our business practices? It's an important thing to really consider when, John Smith files a workers' compensation claim for a little hand injury, right? And it's really getting into the heart of what we do. So it's a good training tool. I think it's a good training tool for how we teach employer-employee relationship defenses and how we pursue them in court, because knowing a process is only as good as knowing the reason why the process is in place.
Sure.
Right?
Yeah.
So that it really covers our real discussion on the issue. I know you went through.
Wait, what?
Wait,
this is.
No,
I hope this is not coming to an end because
hold on.
I have been anticipating this opportunity to speak with you.
Right. Since I brought this to you this morning. Yes.
For years. I mean, years. Right. Years.
Are you? Second.
I feel like we're only a few minutes into it, and now I can sense. I can look in your face. I see you wrapping it up.
No.
I just never.
No, we're just wrapping up the first first segment, right?
Okay.
I was going to say, since I've had the pleasure of bringing you on for this episode, is there anything new? Is there anything new that we want to tell our listeners about what's going on in our world?
In our world?
Yeah.
Is this? I can't tell if this is a setup. What?
Well, this is a setup because if everybody doesn't know, New York State is fully virtual.
Oh, okay, all right. Okay, this is the first time since your last podcast was after the state went fully, before.
It was before, yeah. So the last one became virtual after last month's episode. And Greg, what do virtual hearings mean for our clients?
Well, first it means the ease of bringing people to court and defending your case has increased. And that means it's increased or gotten easier for us as defense attorneys to get to all your hearings, to not waste your time waiting in traffic, travel time exposure. You and I have 24 attorneys working with us here, and on any one given day, there's a snowstorm. We have 20 attorneys traveling back and forth to court. I do fear for their safety at times, right? I don't want workers' comp claims against us. So from our perspective, life's gotten easier. But from the client's perspective, life's gotten a lot better. We just completed in March a review for one of our clients who happens to be a large staffing company. And we were able to show that by attending cases virtually, and in their case, we're going to about 90% of their cases virtually, that we saved them 26%.
That's an amazing cost savings.
In cost.
Yeah.
And, I know that for our clients, we're a bottom line cost. We're just an expense item. We're the red. And so to me, that's very meaningful, but it also means other things. I think about my retail clients who will literally say to me, Greg, we're super busy. A department store client.
Right, don't take them out of holiday season.
Please don't pull my store managers, my captains, my supervisors out in December, January, February, because Greg, we're slammed. We're so busy. And I'm like, well, we want to defend these cases. You might have a good, solid defense, but we can't get somebody to court because they can't spare a day of their floor manager out of the office. Well, guess what? Now they can come to the hearing via WebEx on their cell phone. In fact, the board released an app so that witnesses can appear on their iPhone or Android device through an app. This is the greatest thing that's ever happened for us and able to marshal witnesses and get them to court. So, I'm very excited about that. And then the final thing is, we have, I would say, a pretty big practice. I mean, we are thousands of cases. We are in 31 different courts on any one day. And again, 24 attorneys, multiple jurisdictions. Very complicated. And unfortunately, the downside of that is, you get some fragmentation. We have situations in the past where a client has said to us, hey, I really like Christian. I really want Christian to go to all my cases.
Only one time?
That's happened many times.
Yeah,
and I say, well, listen, Christian cannot be in Buffalo, Albany, Harlem, and Mount Holly, New Jersey all at the same time. He just can't do it, so I have to spread it out. Well, the good news now is, and we've started to have this conversation with clients that we have a lot of files with, hey, do you want a dedicated team? Do you want dedicated people? Right, so we've done this with you and one of your clients in particular. We put all the cases on you and your senior associates, and now that client has this wonderful continuity of both oversight and the attorneys who are handling their cases and the same paralegal on all of their matters.
Right, it's a good area of predictability.
Sure, and I think that's the biggest. That's going to be a great impact, and particularly for clients that have, where we live in the market, they have very particular risk. Right, there's a reason that they're hiring us. There's a reason they're self-insured in general. They want someone who understands their program,
right?
What their return to work policies are going to be, how that interacts with any of their disability or leave policies, information about the specific risk, the locations, who's going to come testify, what kind of information can they bring. That's a huge advantage that gets squandered when your attorneys are fragmented, when you have an upstate attorney, a mid-state attorney, a downstate attorney, a different attorney for Jersey. It can all be the same person now. And that is really going to have a big impact. And I know a lot of people promise that to clients, but then, the realities of trying to field a big team and cover a lot of hearings in a lot of places mean they get a fragmented response or they get a fragmented representation. So that, I think, is going to have a huge impact for clients and, something that I think is really going to impact the case outcome. So that's something we're going to be tracking as well.
Yeah, I totally agree. I actually couldn't agree more because I think that that's what the system used to be before virtual hearings, right? Where you'd have downstate counsel and you'd have upstate counsel simply due to logistics, travel, and time. And really eliminating those barriers now allows employers and our clients to really make the decision of who is really the best, who is really the best, and it's a decision point where we've seen success come through to our door because clients have made that decision and decided that the best resides here. Right? Yeah. And whether it's downstate or upstate, virtual hearings now makes that a real possibility. The board released its annual report on virtual hearings earlier this year, and about 50% of every hearing had one virtual participant. That number is going to skyrocket now that every hearing point is capable with the technology in place.
Yeah, and it's mandatory too. So yes, you can appear in person, but it's mandatory to check in online.
Right. It's almost like forcing you to do it because it's like if I have to check in virtually, then why am I going to be there in court for a settlement approval hearing?
Well, I'll tell you, this is anecdotal, but we just had a client meeting in Arkansas, where they called in all of their counsel across the country and all their comp counsel for a big, meeting, basically the national meeting. And they said, "What's going on in the New Jersey? What's new?" Okay, and our attorneys, it was our partner Declan and Tim Kane, who said, well, what's new in our jurisdiction is virtual hearings. And they said that every attorney there was asking them questions about how does it work, and because New York is the only one in the country. Right. Now, Florida does allow some virtual hearings in some courts, not all of them. Right. Ohio had a virtual hearing program, and then they scrapped it years ago.
Right. Okay. That's actually why we thought
this might go away. Right. We were worried, but here's what we know now:
out.
We are the only ones nationwide that have a 100% virtual system. Awesome, totally interesting, and we're definitely talking about this with attorneys from other jurisdictions. Now, our other big practice, New York's a big part of our practice, but New Jersey's big. Man, can you imagine if New Jersey went virtual? Like, what a great improvement. Now, New Jersey does allow doctors and witnesses to appear virtually. And they've done that for years. But it's really very seldom relied upon. It's not really that often. New Jersey doesn't really allow out-of-court depositions or discovery. So, a lot of stuff still in New Jersey has been in person and not virtual. But, man, I would love for New Jersey to go virtual, too, because it is just clear to me that the client benefits far outweigh the small faults of it, which are things like, hey, you don't get that face-to-face time with your opposing counsel.
That's true.
And that is different. Screaming and yelling is a lot different over a WebEx than it is in person, right?
I don't want to pound my
I am
desk.
A slam my
I want
hand
to pound
on the
your
table
desk
and scream kind of guy, but sometimes that does. That's on video. That's not that compelling. So.
Well, what's funny? It's like I've always been a Jersey boy through and through, but every time New York does something well, New Jersey's not going to be far behind once they see New York doing it. So. Once they see it, I mean, it's still in its beginning stages.
Well, let's put it this way: New Jersey in March, went to finally mandatory electronic filing.
Okay.
So that means we're only 20 years behind New York, which has had mandatory electronic filing and e-case forever. Okay. So, I guess we're talking about 2039, 2040. They'll catch up to
it's
going to happen.
It's going to happen just a little slowly. Mm-hmm. Mm-hmm. Well, Greg, I know that you want this to happen forever. You want this to last forever. But guess what? We are doing something next month. Mm-hmm. Maybe if the viewership likes your voice, we could bring you back on next month. How would you feel about that?
I'm in. Yes, I don't even care what the topic is.
More schedules being arranged to put someone out of the office.
Somehow the whole firm's on PTO. Just what happened here?
I walk in on a nice May day. It's it's just me and you.
Just interviewing, and your choice will be me or the receptionist. That's it. Just what are you going to do? All right.
Well,
thanks for having me. Defend from day one. Thanks for having me.
Well, you're the only person to say it more than me in the first podcast. Maybe that's your way in, right?
Ooh.
Yeah.
All right.
Well, it's been great, Greg, to have you on for the first time.
Thanks
2 years. I thank you for all you've done for us here. It's been a great journey that's going to continue and get even better. Mm-hmm. So for Greg Lois, this is Christian Cison reminding everybody to defend from day one.